This podcast is brought to you by Amusement Warehouse Magazine, the industry's largest trade publication. We cover amusement parks, carnivals, fairs, festivals, history, safety columns. We really got it all when it comes to the amusement business. Only remaining print publication in the amusement industry on a regular basis. So if you're interested in what the amusement industry has to offer, subscribe today. You can subscribe by logging on to amusementwarehouse.com, carnivalwarehouse.com, or amusementparkwarehouse.com. Welcome to another edition of the Amusement Warehouse Podcast. Today we have with us, looking concerned, I don't know what face that is he's making, is Wayne Pierce, the founder of Adventure Law. Wayne, thanks so much for coming on. Wayne, can you hear me?
Ron, I regret to say I do, and you paused again. I don't know what that's all about.
I think your internet might be a little slow. Speed it up over there.
Well, I'll give it some caffeine promptly.
So the listeners might be asking, what is Adventure Law? And actually, I'm asking that myself. What the heck do you do over there at Adventure Law, Wayne?
There are two components to that. The first is that I'm an industry guy, and because I regard my industry as being in the adventure industry itself, that sort of leads me to that branding, if you will. But it's also a way of looking at life. And I feel like we have our own adventure. We run a small business like many of your watchers and listeners do. And like any small business, it's every day is a new adventure. Every day is something going on. We just happen to be serving people who make a living bringing adventure to other folks.
That's pretty exciting. So at least there's not a lot of competition, huh? Not overrun with adventure lawyers.
Well, the niche is a good niche, but there's not a lot of people who think of themselves in the way that I do. In fact, I don't really know anybody who thinks of themselves in the way that I do. I feel like, though, my purpose in life is to promote, to protect the adventure, because without that novelty, that spirit of joy and eternal youthful outlook, the business, I don't believe, would exist as we know it now.
Gotcha. So, but when you went to law school, did you have the intention of getting into this area of the law, or were you going to be whatever, contract law or a personal injury or something, and then I just stumble into this field?
Well, I had graduated a long time ago, back when God created dirt. I completed my ROTC obligation. I was a JAG officer in the Army. And I came back home in 1986, joined a firm in Baltimore, and my supervising partner at the time walked in. He had a 1/4-inch file. He dropped his file on my desk and said to me, "This has something to do with a merry-go-round. Run with it." So I did. And it just so happened, I didn't know it at the time. It's funny how opportunity opens up in front of you. And if you seize it, it can go a long time. I didn't know it, but in 1985 and 1986, there was a major insurance collapse all over the place, but especially in the adventure industry, in the amusement industry. And one of the phoenixes that arose out of that set of ashes, happened to be Allied Insurance. And their first case in Maryland, because of the my supervising partner's willingness to give me the opportunity happened to land up on my desk. And so out of that opportunity, it basically became a year of pursuing opportunities and dreams serving this industry.
That's pretty cool. And the case was pretty interesting, fascinating for you?
Well, do I have to tell the truth? It was the kind of case that would not go to trial today. Let me say that. But it was a fairly heavyset woman with a 3-year-old child who wanted to ride standing while her 3-year-old was on the carousel horse. And her testimony was that the brass fitting that holds the pole to the crankshaft fell off and smacked her right on the head. And my ride attendant claimed to have seen it, claimed that she threw her big fat ass up on top of the horse right at the exact moment, and that she caused 4 quarter-inch bolts to simultaneously snap, and that's why the brass fitting fell and hit her on the head. I was a little bit dubious about whether or not that was actually what happened. But, at the time, there was a lot of reports about counterfeit bolts out of Korea and things like that. But we threw away the bolts. And so we had basically no opportunity to prove anything. And we went to trial because they dropped the ball and couldn't prove who the show owner was. And we should have won. And in a fair fight, we would have won because they couldn't prove that. But on Friday afternoon at 3:30, when they rested, and mind you, this judge always goes through the end of the day, 4:30. At 3:30, they rested. And I moved for judgment. They didn't prove whose carousel this was. And the judge let him off the hook and said, all right, gentlemen, we're gonna rest for today, and we're gonna come back on Monday morning, which gave them. I should have won that case. It gave them the opportunity to pull the case out of the fire, so we settled it on Monday morning when they were able to prove ownership. Kind of trial that would not have happened today, but in the go-go days, that was the kind of things we were willing to roll the dice on.
That's pretty interesting. So how did that lead to more stuff? Did you just Allied liked what you did? Allied loved that you lost, and they said, I got to get that guy again?
Well, now, but wait a minute. Have you ever met a seller that qualified as a loss?
It was the first time he lost.
I would say we had a marriage of outlook on life. There was a lot of go-go-ness in how the game was being played then. And I enjoyed that. I respected that. So the second time we went to trial, which was about 1.5 years later, we were ready. And that second trial, this gentleman had put his child into a Hampton umbrella ride, cars, and he claimed that when he stepped off backwards off the platform without looking, a 6-inch electrical cable miraculously and mysteriously rolled in immediately underneath of his foot, so that when he stepped off backwards without looking, he put his foot down on this 6-inch cable, rolled his ankle, broke his foot, and we proved the ludicrousness of that and sent him home. That was a defense verdict, a long string of defense verdicts. I've been to trial probably more than anybody else on amusement ride cases in the universe. I've had about 52 or somewhere in that area. That's a lot. And that that has been a long run that I've enjoyed very much, adding that to my life's work.
That's probably another one that wouldn't see trial today. Wayne, you there?
I'm back. I don't know why you pause on me. I don't know what's going on.
I think you got a lag in your internet there, a little slow. Because we are doing video, so it sometimes lags. I said that's probably another one that wouldn't have got the trial today, huh?
No, that was a fair fight. That was the kind of cases that go to trial these days, if you can find them, tend to be driven by exorbitant demands that just far exceed any possible cost of defense, any reasonable jury verdict. And we were in a great venue with great facts that could not possibly have happened in the way that that gentleman claimed. I'd take that to trial any day, every day, and I think we'd get the same outcome every day.
Is that part of the problem now with like insurance and rising rates and all that stuff? Is that and I know there's an economic aspect to it, but they do seem to settle on some of these cases that probably could be won, but I guess it just doesn't make economic sense to fight it. But then again, it breeds more cases, right? And on another level. So it makes it kind of a dilemma.
It's funny how things cycle in and cycle out. There's this continual evolution of the psychology from an insurance carrier's perspective on how to make the business viable. And, there are some segments that are more difficult to insure, less people willing to bear the risk as insurance carriers. And right now, I think that there's a trend that a lot of people just don't want to take anything to trial, which is just frightening to me, not from a business perspective, but from when I said earlier about protecting the adventure, if you don't fight for the adventure, which is basically what my whole career has been built on, it's going to go away. You're going to lose it. The business will evolve and change into something that you're not going to recognize anymore. No one's going to want to do because it's not going to be any fun.
Where's Action Park when you need it?
Well, I'm impressed that you even know what that is, since they got driven out of business 35 years ago or something like that.
I grew up in New Jersey and I went there many, 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 many times.
Very good. And see, but that's the side of the business that I kind of think has I think they're escalating. I think they have an opportunity. And it's not from the balls to the wall in the way that the Action Park did it, but I think it's more of we have an adventure attraction subcommittee within ASCMF 24. It was formed about 15 years ago. And the kinds of attractions that populate that subcommittee, trampoline parks, mountain coasters, aerial adventure courses, otherwise known as zip lines, hay rides, those kinds of bungee is in there. Those kinds of things, I think, represent a niche that has a viable course. They've found a way, I think, to tame it down enough to take away enough risk. It's not foolproof, don't get me wrong. Nothing is foolproof. But they found a way to find enough risk and still make it participatory in a way that attracts an extraordinary number of folks to those kinds of operations.
They're fun. I mean, even Action Park was a lot of fun. You knew you're going to get a scraped knee or something when you're there because that alpine slide or whatever would always get you somehow. But, we went all the time, and we'd probably still go today if it was around or we were still kids. like that. I mean, I did see people that had that rope swing where you swung out over the lake, and inevitably somebody wouldn't let go because the water was freezing, and they'd come back and they'd smash into the little slide thing with the carpet, and they'd roll back into the water, and the lifeguards would jump in and save them. But
God bless them.
it was a lot of fun. I mean, it really was, and it's almost like a shame there's nothing like that. But you know, they go for that zero exposure type thing, so that makes it, like you said, less adventurous in a way.
Well, let me give you another example. In January of 2011, I was on the IAPA FEC committee, which was unusual in itself because normally you have to be a constituent, as they call it, and they allowed a lawyer onto the FEC committee. And Ben Jones committee chair, circulated an article, and it was the front page of Entrepreneur magazine. And on the front page was Jeff Platt, who is was at the time, the son and eventual owner of the Sky Zone trampoline park chain. And at the time, he had maybe 6 or 8 locations, and there was only about a dozen trampoline parks in this country. And I wrote this really, really, really good email with 8 points, all of which I could substantiate on why this was the next flash in the pan. And 10 months later, I ate every single one of those words. I was asked to join the founding group and have served as general counsel for what was then known as the International Association of Trampoline Parks. We've since changed our name, capturing what I believe is this movement that I'm referencing. The new name has the same acronym, IATP, but the name is now International Adventure and Trampoline Parks Association. And I sent my email to Jeff Platt, who was the first elected president for our group, because I thought it was hilarious how absolutely dead wrong I was. He took my email, he put it in a picture frame, and he mailed it right back. So I was humbled. But I've worked with those guys very closely, done a lot of, that's been one of the niches that I've been able to serve and do a lot of good as well.
So when you were working for that other law firm and you started to take on a couple of these cases, what stimulated you to start your own firm and go out on your own and devote your law career to doing this sort of thing?
Well, if I was being lazy, I could just say one word, fate. But that was really, I don't believe, an accurate summary of what happened. In the end of 1991, I asked Dan Dudley, who I had worked with. I'd hired him, used him as an expert witness in that electrical cable case I told you about. And
Dan Dudley was the chief ride inspector for Maryland, right?
Well, he had been for, I'm not sure how many years. At the time, he had left and was out on his own, consulting, doing inspection work and things of that nature. And my question to Dan was, I kind of like this. What do I need to do to turn this into something? And he gave me a list, and I wrote it all down right off the top of his head. He said, well, you've got to subscribe to Amusement Business. That was the first thing he told me. He told me you've got to join certain groups. And he included, the OABA and on and on and on. But he went right down the list. And I put that right underneath of my desktop under glass as a reminder of the things that I needed to account for. And one of the things that he did not include on that list, because I don't think he would ever have assumed I would be that stupid, but beginning in 1993, I decided that I needed to master the regulatory world that the adventure industry, the amusement industry lives under. So I spent about 2.5 years of misery compiling every stinking statute, every regulation, every attorney general's opinion, on and on and on. It was a compilation. And it was, by the time I was finished, back when hard copy was a real thing, it was about a 7-inch monstrosity with an extraordinary volume of information in it, which kind of like became uh, my resource. I could reach into that and find things and turn this into something. So coming forward now to your particular question about why did I go out on my own, it was more of a match. It was more of a right sizing process. I wanted to find a better way to provide more value at lower cost. That was the economic reason for it. And I felt that by lowering my overhead and making myself, positioning myself so that I was better able to meet these types of issues, that I would be more effective. And I think, by the way, this month happens to be 20 years for us.
Congratulations.
20 years this month. And so I went from being at the third largest law firm in my state. There was about 180 lawyers in that firm, to I now work with myself. I work with my wife. I work with my oldest daughter, and I work with someone that I refer to as my third daughter, who is the daughter of my wife's best friend from college. So we've known her since she was adopted, and she came and has been working here. And the three of them more or less account for our immigration H-2B practice, which is an important part of what we do, meeting the needs of the industry. And then I am the general troublemaker, troubleshooter, with lots of other balls in the air, trying to account for things.
That's an interesting beginning. So that was around 2000. It took you a while to leave.
You dummy. I was at, it was actually two firms from 1986 until January of 2005. And then the last 20 have been here with our name on the door.
Pretty neat. How many different organizations and industries do you work for and in?
Shh.
I can hear you.
You're back. I regret that you keep freezing. I'll be sure to pay Bill Gates more money next month.
You're fine on our end. Yeah, I can hear you the whole time when you're saying shoot.
Okay. Well, that was for dropping you. So prompt me with a prompter.
Oh, good. What industries do you cover now in the with adventure law? Like, where I know you do carnivals, you do maybe some park work, trampolines.
I think of them as segments, and the segments that matter to me are parks, carnivals, water parks, trampoline parks, inspectors. There was a time, curiously, of FECs, Family Entertainment Centers. There was a time when I was asked to serve as the advisory board legal representative for the regulatory agencies. They came together as the Council of Amusement Ride and Equipment Safety, I believe is what CARES stood for. And so I was on their advisory board for 16 years until they decided to go subterranean in 2019. They decided that they didn't like outsiders poking around. There were 6 of us on the advisory board. And so they I think, played fast and loose with the sunshine laws, and they've reformed as a task group within F24. And the reason why that's momentous is because task groups are subterranean. Task groups are invitation only. There are no minutes. So they basically have a veil of secrecy that ASTM lends them as a task group.
Interesting. Interesting. So how safe? I mean, people, maybe somebody's watching this, not in the industry, but how safe is the carnival industry, the FEC industry, all those places in general? Because people think, my mother used to tell me when I was little, don't ride those rides. They put them up, take them down, blah, blah, blah. But when you really look at the numbers, like what people find?
Well, I want to take a sidestep before I answer you directly. And I want to make a point as to what in the world it means to be safe in the first place, because that word gets thrown around a lot. And if you were in one of my classes, I would be beating you up for even bothering to use that word. If you look up the word safe in the dictionary, the first definition is free from risk. So I challenge every viewer to name one single human activity that is free from risk. I don't believe it exists. So one of my causes is to refer to optimal safety. Optimal safety is a term that I borrowed from another industry that I think makes beautiful sense. We are balancing. We are finding a place where we achieve that optimal blend of it's three things really. It has to be fun. There has to be a function, a positive contribution to society. It has to be something that is cost effective, or no one will be able to afford it. And when you balance these factors, basically that becomes industry practice. Coincidentally, that's where people evolve to naturally in the wild, as they say. They evolve to a position of optimal safety because of some of the factors in our society. And within my world, what I'm now calling optimal safety, it's, I think, quite defensible. So whatever barometer you want to use, whatever measuring stick you like, whether it's comparing to other activities, other comparable activities. If you try, I once had an expert who said, if you can produce, if an activity produces fewer deaths than electrocution from lightning bolts, that's safe. And, that's a defensible argument. And it turned out that at the time, I don't know, I haven't looked at this number lately, but at the time, 89 people got electrocuted in this country from, standing outside or whatever. And have you noticed that 20 years ago, I would say, there were several websites that were devoted to hawking the numbers game, and those websites have sort of folded. They've sort of gone away. Even my dear friend Kathy Fackler, who is basically I would say a consumer who had an unfortunate accident, and she turned that into about a 25 year run within F24. I really respect her. She would show up. She was the voice of reason. She would listen to folks, and she's now hung it up. Allowed her website to, pass away. She used to every year, like clockwork, send Freedom of Information requests to all the state agencies that collected accident data. And then she would post that on her website. And there's not enough juice in the squeeze for people to really take that fight on. I don't see that anymore. 20 years ago, as the internet was taking off, that was a common thing. Not really so much anymore that you see that kind of traction being made.
Well, I guess it's relative risk, right? I mean, it's like there's risk associated with everything you do, like you said. But you're taking an inordinate amount of risk by doing something. When you look at, I mean, I remember when I was studying this a little heavily, basically with the carnival ride, there was, a death every other year, give or take, something like that. But then when you look at the total number of rides taken, you're talking hundreds of millions, maybe a billion over 2 years or something like that. That's a pretty darn safe thing to do. I mean, there's those, when you look at the, when it used to be, what was it? Some federal agency used to keep these statistics, but there were more hospitalizations from playing billiards, than there were, amusement ride accidents. So, when you think about things being safe, I think you got to put that right up there with everything else. Now it's adventurous. It gives you a thrill. So there's the feeling of risk, but the real risk is really not there.
Yeah. One of the things that I fight for is trying to develop a common language so that we have a basis to be able to make the argument that you're alluding to. I would acknowledge that if you just pluck numbers out of context, like I did earlier when I said 89 electrocutions per year, well, if you don't have an exposure unit attached to that, those numbers don't mean much. You can't compare without an exposure unit. And unfortunately, the analysis breaks down at that point because there's really no consensus across industries for how to define an exposure unit. And if you
look at exposure, you're meaning that amusement ride people are sort of running towards it, going on it, whereas with the lightning and rain, most people are running away from it. They're going inside. They're not exposing themselves to lightning. So the universe is much smaller.
No, that's not where I'm going.
Oh, I'm sorry. Okay.
In the ski industry, for example, and I've dealt with those folks from time to time. They measure their exposure unit by skier visits. So if you buy the ticket, that counts as a unit of exposure. So whether you're there for 1 second or you max it out for every available second all day, that still counts as one exposure. And whereas in the amusement industry, we've sort of settled on how many, I think more often than not, the exposure unit is rides given. So if somebody gets on for, and pays the money for, even if they're on for 1 second, that counts as an exposure unit. But, some rides are a lot longer than others. Many of them are a minute and a half. But some of them can be substantially longer. And so that variability in the exposure unit does make it difficult to compare things to. I've tried to push to come up with a way so that we have a common reference. If you look at F-24, for example, they have the beginning of a exposure unit. In the F-24 standards, it says that it's not considered mandatory, but that it's discretionary. You should try to identify whether the accident was in the queue area, getting on, getting off, or during the ride. So it's a combination of a geographic analysis and a temporal analysis. Was it during the ride, during the time of the ride? But they've not been able to go any farther to get consensus within F-24. I've when I push, I've suggested at different niches that I've worked with. If we can come up with a way to capture that, then we got something. Then we can really, make our argument, I think, much more effectively, because we can freely compare ourselves. For example, in my trampoline group, there's a strong tendency to compare ourselves to sports activities. And, there's some validity to comparing jumping on a trampoline to playing sports, or like football or soccer or something like that. But it's really difficult to find statistics to actually allow you to freely make that change, or make that analysis, comparative judgment, in a useful way.
The other interesting thing, or another interesting thing I think about a lot, is how you make things, I'm going to use a bad word and you're going to get mad, but it's okay, safer. Like when you have an industry that is, or a thing or whatever it might be, that is really so safe, when you approach zero with so many different factors, you have to be careful in a sense, because you can take, I remember with planes, the federal government years ago, they said, well, we have these infants that are being held in the lap and they can get hurt, if they're in their parents' lap. So we're going to pass this legislation that they have to have a seat. Well, the unintended consequence was it's more expensive to fly now, because they have to buy a seat for the infant. So more people drove, and therefore they expose more people to danger, because it's more dangerous to drive than it is to fly. So they thought they were doing good, but really it turned out being bad in a way. And, with amusement rides, what things can you do? Do you have more inspection? Do you have more this? Do you have more that? Because I'm always fascinated by, because we are not federally mandated, especially the carnival part of things. So every state's different. But do we see giant differences between those states that inspect every single time you set up, those that inspect once a season, those that maybe don't even have a department to inspect? Is the physical act of inspecting, and how often does it have any impact at all on safety, quote unquote, or the number of accidents, or whatever accurate word my lawyer Wayne wants to use?
All right. Well, I heard about 12 questions in there. So I'm going to start picking at some of them. So one of the things that I used to push when I was on the advisory board for CARES, one of the things that I would push them on is prove that your particular inspection regime, your protocol, is any better than anybody else's. Prove it. And, there was some good, competent, smart folks on there. And no one ever came even remotely close to coming up with a rationale for why any inspection program is any better than any other inspection program. It just wasn't there, at least not on their volunteer time.
Even the inspection programs that don't even have state inspectors.
Correct. And I will say this to you, the incident rate is so infinitesimally small that when you start shaving, when you're starting close to zero and you're trying to show a distinction between, well, I do it this way and it has this result, trying to prove efficacy, trying to prove that you have a positive effect with such a minimal actual exposure rate, very difficult to do. And I was pushing them for a reason, because I wanted them to appreciate that, but for the good graces that a particular state legislature pulled it out of the air and thinks that maybe this will be a good idea, there really isn't a basis for you to exist. Now, let me combine other parts of your question by using this illustration, what we're fighting about in the state of Florida right now. So you will recall that in March of 2022, 14-year-old Tyrese Sampson fell to his death at the Orlando Eagle Drop, came out of that ride and was killed, fell and died. One of the things that came out of that is that a state senator out of Orlando filed a bill, which miraculously passed unanimously in both houses and was signed by the governor and became the law. Oh boy, I want to say late 23, maybe. So what it did, though, was it created this unachievable house of cards from the industry's perspective. And we're now arguing, we're now making our case to the Department of Agriculture and Consumer Services on how to turn this completely unsustainable statute into something that will work. And so just one of the examples that makes my point, the statute can be interpreted to mean that inspectors must be smarter, must be more effective, must second guess the manufacturers. Well, that completely turns the industry on its head. Anybody who's anybody knows that the amusement industry is built on the premise that manufacturers are God, little g. They know the most about their equipment. They tell the rest of us, they and their designers tell the rest of us what to inspect for. So that's a fundamental F24 principle, is that a designer determines the inspection criteria, not the inspector. And I beat up my NARSO class participants on this exact point every year, and I'll be doing it again in a couple of weeks. You do not determine inspection criteria. Designers determine inspection criteria. And if you cross that line, you've just set your life up for a world of hurt. And
From a liability standpoint, I was thinking, right?
And other things, yes.
But that poor inspector now, he's like, oh, you should have known that. Oh, you should have known this.
Well, and this statute can be read to mean that you have an affirmative obligation to find new inspection criteria and to order non-destructive testing. And I'm not just talking visual, I'm talking mag particle or something along those lines. You got to just pull it out of your butt. You got to make it up. That's how it can be read. So we have presented last month a proposal back to them trying to make this livable so that the industry, because that turns every fundamental principle completely on its head. One of my arguments with the Florida Department is ASTM does not actually say that the goal of the industry is safety. It doesn't exist. When you actually read the F24 standards, there's probably 250 pages of it. When you actually read it, the guts is found in the design standard, and the guts are that we mitigate hazard. We keep incrementally improving. It's a process, but it's not an endpoint. We never reach a point where we say this is safe. And so I actually did a word search for the word safe in all of the F24 standards. And it appears, if I recall correctly, about 6 times. And not because it's the standard that we operate to or design to, it actually appeared to me that they were used in the correct, proper sense. So, for example, there is a requirement in the design standard that a ride must, when it fails, it must fail safe. But notice, it doesn't say it has to be safe. It says when it fails, it must fail safe. Well, we've drawn a big box around that by saying fail safe. because that makes all the sense in the world, that if it's going to fail, we want it to fail in a way. So if you got a load high and something, the arm gives out or whatever, when it drops because gravity takes over, we want there to be no person underneath of it getting splatted. So that use of the term fail-safe makes all the sense in the world in that context. But nowhere else does it say that. And I think that this Florida statute just fundamentally redefines basic principles. And what's really hilarious or sad is that the statute also indicates that all regulations must be patterned after F-24, and that we must adopt F-24. Well, those are hopelessly irreconcilable. That is a conflict, to say we're going to have inspectors second guessing manufacturers. We're going to have inspectors doing a better job than the manufacturers. It just cannot be done. One of the guys in our group, who happens to be an engineer, made this point. He said, look, I have an engineering degree. Unlike most Florida inspectors, I actually have an engineering degree. He says, I cannot ethically do what this statute is saying we must do, because I will never have all of the information. The manufacturer would or should or could have all the information, but I, as an inspector, will never have the accident data, the design criteria, all the specifics, in order to be able to make the determination that they're asking us to do as inspectors.
And are parks in Florida exempt from this, or does this just affect mobile and smaller parks?
Well, Florida's an interesting place. So they have their big park exemption. I think it's 1,000 employees and a full-time safety person, I think, is the criteria for the exemption. So they actually have two forms that they have circulated. We've objected, filed a position paper as to the one that applies to everybody else, small parks, carnivals. It's a pretty long list that will fall under this set of regulations. And then there's the not so big, it's not such a large number of big parks that have a completely different inspection report form that applies to them. Theirs hasn't been mucked up yet. They're technically exempt, but they've reached this, I believe the French term is tête-à-tête, this sort of no man's land of, well, we're going to do this much, but you're not actually going to regulate us. And so they've got this middle ground going on there. But theirs has not been changed. But if they were going to maintain some modicum of consistency, it seems to me that they're going to shoot me for saying this, but it seems to me that the form that applies in the large park context would be modified comparable to how the other one is being proposed to be modified.
Seems to you?
Yes.
The other big thing that, if you're in the industry and know a little bit about it, and certainly from your standpoint of knowing these figures, but the thing that doesn't get touched on a lot, but it's so important, I think, is when you look at accidents or incidents or rides actually breaking compared to incidents that are caused by a patron doing something stupid on the ride. And there's something that inspection doesn't really look at, or all this training doesn't really help to a certain extent. Like, how big is the patron error thing compared to the mechanical failure? Like, what's
Yeah, let me say some things about rider responsibility, which has been sort of a cause in my life, and something that I have been proud to have fought the fight on. So, and actually, I want to begin where it began for me. When I was 16 years old, I went to a carnival that was set up at the shopping mall near where I lived in Bel Air, Maryland. And um, I was there with a couple of my buddies, but my younger brother, who was 14, had a different group. And they were much more on, if we were in Britain, I would say they were much more on the hooligan side. And so while I and my group were chasing after the girls, he and his group got on a Watkins swinger, and they decided that the really desirable thing to do was to swing their swings. And eventually, my dumbass brother swung enough. He grabbed the guy's chains in front of him. He brought his feet up. He was going to push the individual and drive him forward as the ride was in operation. What he forgot was Newton's second law of physics. And so he, being the object of motion, stayed in motion, his seat inverted, and he was literally flying through the air like Superman, feet out, hands out, held by the grace of God by a crotch strap. And I was about, 70, 80 feet away, hanging out with my guys. I looked over, I saw his sorry ass flying through the air. And I remember that ride jock was like bored out of his mind. And here comes my brother Supermaning around. And I saw that guy, that ride jock's face go, wow! And he's hitting the E-stop. And so that's sort of like my beginning. And I will say, I hope my friend Tommy Galen doesn't mind me mentioning his name, but Tommy insists that that was his spot and that was his show, and that he takes great pride in saying, and I was the one who was responsible for throwing your asses out of there. So now fast forward, I wrote a model statute in 1995 that captured the state of the art from a patron or rider responsibility perspective. And I drew on all the best thinking at the time, the ski industry, agritainment as it is known, the equine industry, all these concepts that were floating around at the time. And I'm happy to say my friends at the OABA allowed me to put lightning in a bottle, and we took it on the road. So my model legislation became the basis for about 25 or 26 states adopting rider responsibility. And as a statutory requirement, I'm very proud of that. We did a lot of fighting. I remember going to Lansing, I think it was, to testify. And I had a list of every stupid question I was ever asked and what the answer was to every possible objection. And it went on for like 30 or 40 pages of, this is how we're going to bulldoze this. This is how we're going to win. It became a strategic plan, if you will. And the states that we did not capture were sort of the, by and large, they were deep blue, by and large. They were much more dominated by plaintiffs' lawyers, and were much more difficult to try to get something that's state level. And so one of the things that I do is I now recommend pursuing this at the local level. And because you won't get bottlenecked in the way that many of these states can be bottlenecked at the state level. And that initiative is now being challenged So there is a task group that has been formed within F24. And as I understand, I've been asked to serve on it. There's 6 of us. This is in the last 2 weeks. As I understand it, the charge to the task group is to rip out right of responsibility from F24. It's been on the books for 31 years. It's milk toast. It's plain vanilla. There's nothing inflammatory. There's nothing on the cutting edge about it. But to pull it out and to insert in its place even more responsibilities for operators to make sure that their own patrons don't get hurt. And so that one's, we're in the starting blocks. I don't know where that process is going to go. But I have my own ideas about where it should go.
But you didn't speak to the scope of the patron error versus mechanical failure thing. Where is it mostly this or mostly that, or where? And is it lopsided?
There is a pretty well documented case. When I see accident statistics, I compulsively save them because accident statistics are the life's blood. That's what drives this. And it's very, very well documented. I've actually written articles on it and even the Europeans agree with what I'm getting ready to say, which should tell you something, that patrons account for probably 75, maybe 80% of the accident exposure. There's another 15% or so that's attributed to operators. And then there's a sliver that's attributed to design or maintenance or mechanical problems. Those numbers are pretty well borne out by my personal experience. It's definitely borne out by the published studies that have been done on it. And it's pretty comparable to what I've seen from other participatory activities as well.
Yeah, which should tell you where the focus should be. I don't know if you remember, but years ago when I was doing some PR work for the OABA, I was on a show, and after the show was over, a lady had passed away, unfortunately, from a Ferris wheel, fell out of it. That was one of the subjects of the show, and you gave me all the background on that after the show. You're like, she was drunk and she was rocking the seat and she fell. But, obviously when they retell a story, it's very tragic. And, the headline is, or the top line is, she fell to the Ferris wheel, so meaning there was a problem with the Ferris wheel. But as you pointed out, there wasn't. She was swinging and doing stuff and wound up falling out. But, it seems to me that from the statistics you cited, any, layman or any person who looks at those things can see where the focus should be, right? Where can you do the most good? Where can you make the most difference? And it's obvious that mechanical failure is not it.
Very, very much so. And my dear father, when he was with us, used to say, you go fishing where the fish are. And the causal factor, the etiology, as the medical profession would say, the causal factor is patron actions. And so if you regard the operation of an amusement attraction, as I do, that it is a system, and one of the components in the system is patron participation, then the system needs to factor in, needs to account for that in some way. And all the studies, every one of them, I've spent days at some undergrad libraries researching this to be able to say what I'm getting ready to say. All the studies, whether it's seatbelts, motorcycle helmets, using chainsaws, all kinds of things. There's 3 things that need to be there if you want to have a desirable outcome. They are patron education. That's the first thing. That's kind of obvious. The second thing is you need to have a law regarding it. That has a measurable impact. And the third thing is you need to enforce it. There needs to be a consequence for failing to abide by the law. And when you have those three things, that's another example of capturing lightning in a bottle. You actually do have a desirable outcome as on the experience. And that's what I'm afraid of with the current proposal to remove the rider responsibility from F-24. I think it's going to have a very significant unintended impact.
Well, keep fighting the good fight, Wayne. Believe it or not, we've been talking for an hour.
I didn't get a chance to convince you of anything.
Well, the good part is you answered more than one question in the answer, which is good for you. I'm so proud of you.
Terrific.
It's always great talking to you. Thanks for all the yeoman's work you do for the industry and everything you do. And I hope to see you in Gibtown next month. And keep up the good work, man. Appreciate it so much.
And I hope we gave the boys at Gibtown Club something to talk about when they're cutting jackpots on Friday nights.
That's right. That's all they'll be talking about.
Good.
Thanks again, Wayne. I appreciate it.
You betcha.
This podcast is brought to you by Innovative Ticketing is the ticketing source made for the amusement industry. Our staff of professionals can guide you through your setup, assist with customer service, even on the weekends when you most need it, and help increase your sales through promotions that work. Innovative Ticketing is the ticketing source made for the amusement industry. Sign up today at innovativeticketing.com.